Good morning, everybody. Suburban Sentinel here, coming to you once again from deep inside the Arabian Peninsula. It was just over 2 years ago where this whacked-out teenage boy stole his mother's AR-15 and proceeded over to the Sandy Hook School in Newtown, Connecticut, and massacred a bunch of school children and several teachers. Just a few days ago, the parents of some of the school-age victims and the estates of some of the deceased adults sued several companies, including but not limited to Bushmaster Firearms, who is the manufacturer of the AR-15 used in the crime, and the gun dealer who sold the AR-15 to the perpetrator's mother. I want to spend a little bit of time talking about this lawsuit. As gun enthusiasts, there's a fair chance that this lawsuit will come up in your ordinary conversations. More importantly, this suit is just as likely to become a topic in civil discourse with those who are either ambivalent towards or downright hostile to the world of firearms. And I believe it is in our best interest to be able to discuss or frame the issues and address the merits or lack thereof about this case. First, let's briefly examine the applicable law. Gun manufacturers, distributors, and dealers are generally immune from liability for acts committed by a third party that are either negligent or criminal involving the firearm sold, so long as the firearm was legally manufactured, distributed, and/or sold. Now, this is statutory protection under federal law by way of the Protection of Lawful Commerce in Firearms Act. So, gun manufacturers, distributors, and dealers are generally immune from suit. But note that there are certain exceptions built right into the statute. And one of those exceptions is a legal doctrine known as negligent entrustment. So what is this whacked out negligent entrustment business? Well, negligent entrustment is this obscure legal doctrine which states that if you either put someone in a situation or give them an object and you knew or reasonably should have known that that situation or object could cause harm to that person or a third party, you can be held liable. By way of example, suppose a man walks into a gun shop and tells the proprietor he wants to purchase a handgun because his life sucks and it's not worth living anymore, and he can't wait to get his handgun and one round of ammunition, so as soon as he walks out the door, he can blow his brains out and put an end to his misery. Well, under those hypothetical facts, if the shopkeeper sells him that pistol, he could be liable for negligent entrustment because he knew or should have known that this man who walked into his shop was going to cause harm to himself or another. So how does this negligent entrustment theory apply to this lawsuit? Well, on its face, it really doesn't. The Newtown shooter was not at all entrusted with this weapon. He stole it. In point of fact, he killed his mother in order to get it. So it seems that Bushmaster should be protected because under the law, it legally manufactured and sold this firearm to a distributor who sold it to a dealer who sold it to Nancy Lanza, the shooter's mother. There really was no entrustment. But In this case, the plaintiff's attorneys are doing a little bit of creative lawyering and have their own theory and rationale. And by the way, both figuratively and literally, do not shoot the messenger. I do not agree with this logic or lack thereof. I'm simply conveying it. And what they're saying is that the AR-15 was designed as a military weapon. And as a military designed weapon, it is per se, or in other words, automatically, beyond the safe handling capabilities of all civilians. And Bushmaster and the distributor and dealer, by putting the AR-15 into what's known as the stream of commerce, or in other words, by selling the AR-15 to the public indirectly, knew or should have known that a civilian would hurt himself or hurt others because this military weapon is too dangerous for public consumption. So let's take a closer look at this quote-unquote novel legal theory. First of all, it is factually inaccurate. The AR-15 is not a weapon designed for military purposes. In point of fact, the AR-15 is derived from a weapon designed for military purposes. You will note that the AR-15 civilian platform has no full auto capability, no grenade launcher, etc. So let's say a judge or jury buys the argument that the AR-15 is a military design weapon or is close enough to a military design weapon not to matter. Let's take a look at the real meat of the negligent entrustment argument. Now, the plaintiff's attorneys are saying because it is a military design, it is per se or automatically too complex or too dangerous for civilians to handle. Well, what about the K-bar knife? Now, the standard issue military knife, or the knife that the Army and the Navy were using during World War II and for many, many years thereafter, hasn't always been designated the K-bar, but that knife was designed specifically for the military. And that knife has been and is still currently available on the civilian market. Is that knife too dangerous for civilians to use? I don't think so. What about the venerable Jeep? That vehicle was designed for frontline combat service just before World War II. And now for well over half a century, the public has been driving various iterations of the Jeep vehicle. Is a Jeep too dangerous for public consumption? They have produced millions upon millions of Jeeps throughout the years. In sum, this lawsuit is both factually inaccurate and logically inconsistent with current policy and law, and is therefore frivolous. In other words, this case is a bunch of BS. Now, there are other claims in the complaint based on other legal theories, but they're not really worth discussing right now because they're pretty esoteric under state law, and it's unlikely that they will see the light of day. If they do, we will come back and revisit this lawsuit. So what will happen with this negligent entrustment theory? Well, in my opinion, the case should just be dismissed on its face. What will really happen? Who knows? But if this lawsuit comes up in conversation, at least we will be able to discuss the facts, the relevant law and legal theories in an informed and rational manner. So I will stop talking now. Thanks for listening. This is the Suburban Sentinel. Please thumbs up and subscribe if you like what you see. Questions and enlightening comments and differing opinions are always welcome. Shoot safely, everybody.